So far, we only have 2 members of the board.
Is everyone just quiet or am I not hearing anything?
Yeah, no, we're quiet.
Okay, okay, all right. Just making sure audio is good. Thank you.
Okay, it's a little after 6. This is Margaret Morris. So far, I'm looking for a roll call. We have Ronnie and Margaret Morris. Michael Hoffman. So I'm gonna go ahead and call the meeting to order.
Vicky's here.
Oh, Vicky is there as well. Okay, so we will call the meeting to order and proceed with the 2 laws that Crystal shared with us a couple of days ago. So Crystal, would you want to walk us through the Knox boxes? What I had submitted for the public was the materials that I had, I think, from yesterday, and there was some back and forth, but I don't think anything changed from what I had from you. So
Hold on, I just want to bring up did you post the changes that Nick had made, the edits?
I couldn't tell from the stream whether what I had the changes.
This is what's posted on the website currently.
All right, hold on, let me just make sure I've got,
There's track changes in here.
no, that I put the track changes so that everyone can see what was being added to what's actually in the code now. But Nick had 2 changes he wanted to see made to that. So that's where, and he had highlighted them, so I just wanted to pull up his what he had sent me, which which is not coming up super fast for some reason. Hold that thought. They were fairly minor. Here we go. Okay. So this was requested by the city's fire department. Initially, the city has had a voluntary lockbox program. The fire department would like to see this mandatory for certain uses. Those uses are outlined in the substance under section 5. Subparagraph A, they wanted to see it specifically for multifamilies, the short-term lodging rentals, and the commercial structures for the city. And their preference is the Knox box system, which is why what we did is we referenced that in here and had that as a brand designate or any other brand designated by the city, just in case they decide that it should change in the future. But Knox box is what's compatible with what the fire department uses now. And essentially, the other main provision of this is allowing an opportunity for property owners to get in compliance. So it allows for a 24-month period for existing properties to get into compliance. Anything that is new construction that doesn't have a CO, they're going to have to be in compliance right away. There were two edits that Nick wanted to add to that, and that is in paragraph A. Margaret, if I can I share my screen and I can just show those? That might be easier.
I was trying to figure out whether I have the right version to send.
No, he actually highlighted what he wanted to add to it, so I'm just gonna quickly share my screen. All right, is it up now?
Yeah.
So the two sections, again, they're pretty minor, are the highlighted sections shall be affixed to the building by a contractor or homeowner. Nick wanted to add that in there. And then also that the keys to the lock boxes are going to be kept in each of the City of Hudson Fire Department vehicles and locked in a Knox key control unit. So those are the two additional provisions he wanted to add into it. And that's it. It's fairly straightforward. I had talked to him about whether he wanted to go more comprehensive. There are some municipalities that go way in depth on this, specifically on the lock boxes. He preferred that not be the case. They wanted it to keep it a little bit more simple and straightforward.
So I did not have any questions about it. Do any members of the committee have any questions about it? Oh, by the way, Tom DiPietro just joined us.
Oh, we see him. Crystal, the municipalities that have more in-depth, are they just like they designate like exactly where it has to be and all that stuff?
Yeah.
I'm just thinking ahead, maybe sometimes it's better to like have that standard set first rather than, let's say a fire occurs and they spend 5 minutes looking for the lockbox or something like that. I don't see anything specific.
That is in some of the codes. It's very clear as to what goes in there. What I did do is I did pull from, in one of the examples I used is in Albany County, the town of Colony has a very specific lockbox rapid, emergency access code provision. I did actually grab certain portions from there that I thought were important to have in here, such as the types of keys that needed to be in, the entrance to the different types of rooms that needed to be available, the building plans, that type of thing. They do go a step further though and talk about, where they want it to be and that sort of thing. The fire department did review that law. I provided that to them as a sample, and they wanted something a little bit more, they thought something to start a little bit simpler would be better for them.
Yeah, my thought was like, why revisit this multiple times? And when there is an issue that arises, let's say a year later, if it's something I wouldn't think like if we standardize where the lockbox is or like, within a certain feet of the entrance or something like that, that might just be more helpful for both the fire department and the homeowners not to have to change those later, and for us not to have to change that law later as well.
I don't disagree. I would want to get the input from the fire department as to where they want that though.
Right, obviously, yeah.
Yeah.
That's my question. Thank you.
Any other questions?
Vicky's handed up.
Vicky, go ahead.
Hi, I'm not part of the committee, but I have a quick question. Is this Knox box mandatory for only the old construction or everybody really? Except, they have to be, the Airbnbs and everything else.
Yeah, it's mandatory for everyone. The new construction, if they haven't had a CO, they have to do it right away. Before they get their COs. For the older construction, they've got 24 months to get in compliance.
Okay, got it. Thanks.
Anything else? Okay, so I think, Tom, we can send this to the informal meeting then.
Sure.
And then I can go from there to the full
Yeah.
council and the formal meeting. I don't think we have any other revisions, but so thank you.
Okay.
The next item is also you're on deck for, which is the burn. Open air burn.
This was another request, by the fire department. They had reached out. One of their initial concerns on what was already in the city code was the, provisions that existed regarding bonfires. Essentially, the concern that the fire department had was that it was a little too ambiguous, with respect to when bonfires were going to be permitted, or the fact that no bonfires could be permitted. And then there was a question, and apparently had come up to the fire department in the past as to what type of outdoor fires, backyard fires, that type of thing that would be allowed. So this was another situation where we took a look to see what was existing in some of the other municipalities that, particularly cities that, controlled and regulated these open burns. And the fire department Nick took a look at this with the fire chief. They found a couple provisions that they liked. And this is, what was put together, essentially, that there is now going to be a regulation as to the type of, like fire pits that, residential properties can use, where they can be used. It also speaks directly to bonfires now, and when a bonfire can be used, and when it cannot be, and the fact that there has to be notification to the fire department about it. So this really did get into a lot more, of specific regulations that the fire department had gone through.
Right, because it's very specific about sponsored events and so forth. for
Very
bonfires.
much so, yes.
Yeah. So in the section where it discusses the previous page, Mike, where it talks about, unless in a smokeless container for food by such, use by manufacturer, and it can only be, dried wood, etc. It's my understanding that things like chimeneas were always banned, is that correct?
I'm sorry, I missed the first part of that. What was always banned?
This is not new, is it, the smokeless container? Because I think that things like chimeneas were always banned.
Yeah, and this is why Nick wanted to have a lot more specificity for residents and also for enforcement as to what can be allowed and what can't be allowed. Because I think that there was an issue about allowing, when residents actually can have some of these fires. But yeah, yes, my understanding in talking to him and going through the code is that yes, these fires they were banned before.
Well, I think, they're quite common. To have, a wood burning fire in a container in the backyard, I think that's quite common.
Yes, yes. And he wanted to allow for residents to do that in a certain capacity. I mean, the fire department didn't have a problem with that.
How under this do they do that? What exactly is a smokeless container?
So there are types, if I don't have an example to show you, but there are like the metal canisters now that you can put as like your backyard fire pit. And those are the type that actually they're smokeless, they're permitted.
So, yeah, I could probably chime in here. Usually what these smokeless containers do is they allow a significantly more airflow into the combustion chamber, which just means that the fire is a cleaner burning. It might be still smoke, but it's considered smokeless.
I got you, okay.
Yeah. Used to be, I think, if I remember correctly, I actually looked this law up previously while I was just a resident. It was okay to, as long as there was some kind of a metal mesh cover,
Mhm.
that was what was permitted. This is new language about the smokeless container.
That was actually really the only question I had was the word smokeless, but I wasn't sure what those containers were. Do we have any other questions on this? Anyone have any questions? Ricky?
I'm good, thanks.
Okay. Again, we'll send this off to the informal. And I'll get you the correct version of the Knox box for the informal meeting. Next item on the agenda. You put on the agenda.
Formula retail.
Excuse me.
Formula retail.
Yes, so I just wanted to mention an issue that came up the last week or so. As you know, we have been working on making the code with regard to formula retail more specific with regard to the point in time in the process. where Formula Retail would be evaluated for the number of stores that were either in the process of being opened or open. And that is going through council, the full council didn't change anything substantive in that other than establishing a clear timeline. And that code enforcement would evaluate at the point that a permit is asked for whether or not it was in compliance. And so in recent weeks, a business had applied for a permit that this would be the 9th location, I believe, where they already have 9, but certainly more than 4. And I think that this is not really an issue for the legal committee to discuss, and that we have established a code. I think that it is more something for discussion at the full council. I don't know, Tom, if you have anything that you want to add to that.
No, I mean, my understanding at this point, first of all. Right now, the discussion is between code enforcement and an attorney for the business owner.
Okay,
Because. It's not clear exactly. What entity is going into that space. Granted, on the website of the business. It seemed as if it was another version, another outlet for their existing business. Since then, we've learned that. The owner is claiming that it is not their. Regular business, and that she would like to just sell antiques there.
excuse me?
That she would just like to sell antiques there under a different name. Now, the question is. Does a different name? There are a couple questions. Is a different name good enough, or does it need to be a separate entity entirely? In other words, maybe a different LLC. Will the existing name of the corporate entity be in any way involved with this extra business, if that's what it is? So right now, those are the issues.
So I think and also the code is all about formulas.
Right, and if it is a formula, it will be stopped.
Right, it is specific to formula. So I
Yeah.
think, I don't see this as something that this committee needs to, discuss. I just wanted to mention that come up, yeah.
About, can
Sorry,
I ask a
you-
question? Chuck Rosenthal, Hudson resident.
Okay,
I had a question though, because you said like that, it was triggered if you go to a planning, like the planning board for a permit, but
no, code enforcement.
code enforcement, but. And correct me if I'm wrong, if a business is moving into an existing space, storefront, and they're just moving in, are they required to go to code enforcement?
Depends.
Pretty much if they do anything, they're going to need to get the permit.
Actually, Margaret,
Not
this,
quite.
I'm sorry, I'm gonna just, is that it? I apologize, I'm gonna interrupt real quick, because this was a conversation I had with Craig when we were looking at the formula retail law. There are certain types of essentially turnkey type changes that do not require a permit. And that was where we had discussed potentially like adding a zoning provision about requiring permits for changes of tenancy and things of that nature, so there can be more oversight and regulation. But as of right now, there are certain types of uses that could go in without requiring any additional permit if they did not require any sort of change to the structure or interior.
But I think it would be
that's
most unusual to have a business come in and make no changes to them, even if you were taking over a restaurant. And so forth, it would be very unusual if you were making no changes.
Well, I mean,
Hang on a
I
second.
could be mistaken, but like my next door neighbor just.
I just wanted to ask Crystal,
Yes.
just, I understand the legality of what you're saying, but in terms of, kind of reality, when somebody, it's an existing restaurant or it's an existing clothing store, they're going to continue to have a clothing store, they would end up looking for a permit for some changes in the layout or something like that. I mean, that was just in terms of,
Like,
I think the intent of the law was for formula retail, so we don't have these like cookie cutter stores popping up in the house. So if it was a business that kind of comes in and already, takes an already established business, they make no changes, that kind of falls out of the scope of what our intent was.
that's correct too. So I just, because I interrupted. Go ahead, Mr.
Oh, okay.
well, I mean, I think if it depends what you're defining as a formula business. I know what you're really after, because my other question about this law is that it seems to me that the first requirement is that you have 4 or more stores. But then it says, in addition, you need to meet these 2 of these other sort of benchmarks, which are real. When I read those benchmarks, what the law is really saying is you don't want like West Elm or the Gap to move in but I don't think any store that has a 9, like this store, that Chick or however you pronounce it, is coming in. My personal guess in reading this is that she probably could come in and open that store
No.
based on the existing law. Well, except for that she has a logo, which is one of them. The other are,
No, those 2 things you just pointed out would prevent the store coming in.
what 2 things?
The substance of the goods sold, remember you were saying there are 2 other things?
Yeah, but it says that 50% of the product that you sell comes from one distributor. In my store, I do not have 50% of my product coming from any one distributor. The only store that would have that is a store that is manufacturing all of their own goods, which is like a Gap or something like that. I would guess that she does not get 50% of her product. I mean, she has women's clothing, children's clothing, housewares. I mean, she wouldn't qualify for that. It's not, is every store painted in every color, the same color? It's
Right,
like the things are very geared towards.
but that's what she's claiming she's not gonna do. So.
I get that, but we're not discussing this just for one
No.
store. I mean, this law is not just for this one store, and I'm saying that really the way that I read this law, and maybe it's your intention, that it's really to not have a major change, like the Gap. But it's not really to stop this woman from opening her store here.
So I have a question for Crystal. Oh, no.
I just want to make that
go
one
on,
point.
go on.
We caught this, the city caught this because the business owner went to
To
the code enforcement
program.
for a sign.
Yeah.
Right, that's the only thing, but once you're applying for the sign, you're pretty far down the road. I think there should be an earlier mechanism of,
Well, that as
and that's a hanging sign. If you're just gonna put a window sign, then you don't even.
but the problem is. You're right. I mean, right now, if you go retail to retail and do nothing, and there's no changes, you're not gonna go before code enforcement. And that we were discussing in a meeting previously is the next step if we wanna, but that's more of a. That's a more complex change to this law that we'd have to, I don't even know if it's, would it be to this law, Crystal, or would it be to?
We'd be changing it to the zoning code. It wouldn't be specific to this law.
So it's a separate kind of issue, but we might go there. So that, and Craig is actually in favor of that. Because too many things can sneak in just by being retail to retail, for example.
So, I want to answer your question about at an earlier point, first of all. Business is going to come into the municipality. It's their responsibility to look at what the requirements are in that location before they go down the path of investing in opening a business, right? And so that's up to them to do their due diligence and to ask questions and find out. So the fact that the first point at which something is occurring in the city is in the code enforcement point, to me, that's okay, because that's pretty early in the game. I would assume that an investor would do due diligence, first of all. The question I have for you, Crystal, when we were looking at the sole distributor language, so Tom kind of touched on it by talking about it being a different LLC, et cetera. To me, if you have a business with multiple locations, yes, they can have product from different brands or whatever, but this distributor to each of those stores is the company that owns all of those stores. So the sole distributor there would be the owning company. So I get it that you're saying in your store, you don't have more than 50% of your stock coming from one manufacturer. But I think that if you are a business with 9 outlets and you're stocking your store, you're the distributor. You're distributing different brands, but you are the distributor. And that's a question,
Okay,
that's
that's
a
not
question.
how I read, that's in the retail business, that's not what distributor means, but so maybe.
I want to put that to Crystal. I mean, that's something for us to think about.
And more importantly, if it goes in and it's the same, we will shut it down. There's no way to get it, I mean, it's a code violation. Code violations get shut down.
Mhm.
I know what you're saying about distributor.
Mhm.
I get it, but I'm just saying, you have a centralized entity that is stocking multiple locations. That's how I interpret, but I think
Okay,
that's
I
something.
mean, that's a
something
better
I
read
think-
of that word, but that's not how I read it.
I think that's something that maybe you need to go back and relook at the language in it. And Crystal, I think that's that's a good point about the distributor and what the exact definition of distributor is. That we
And-
may need to add that.
If we don't define that in our code, which I'm not sure that we do, then it would be up to our code enforcement officer to provide the initial interpretation on it.
Yeah, I'm looking at the code right now. It says 50% or more of in-stock merchandise and or services from a single distributor bearing uniform markings. So I mean, that's very legalese. I don't know how to interpret that.
And that's where you'd have your code enforcement officer actually doing a formal interpretation on it if one's requested, yeah. Otherwise, what you can do is you can always edit your zoning codes to include a very specific definition that you want to apply.
But for now,
I didn't even-
the issue, I think, sits between, as you said, between code and the lawyer and, we don't really.
Well, for this one particular business, but you're creating a law that's gonna
No,
be.
You've already
No, I get your point, and we need to relook at that.
Okay,
I think that's a good point.
thank you.
Definitely.
Can we just step back for 1 minute? I just want to ask one quick question. Sorry, I couldn't find
Sorry,
my
there's this,
Ivy Dane, hi. So just as far as the process goes, right? I just want to get this straight. So because they applied for a sign permit, that's what tipped off this whole thing, correct? Now, I went back and looked at the sign permit application, and I think maybe I misread it, but I don't think it matters whether or not it's a hanging sign or a window sign, like a decal on a window that requires a permit. I could be mistaken about that. Because I think somebody had mentioned that if they just put a sign on their window, then this whole issue wouldn't have come up, but I'm not sure if that's true or not. I'm just wondering, like, is there anything that can be done just about the process? Because obviously these people are in a tangle now, right? I'm sure that they've spent money planning their store, right? They try to apply for a sign and they're finding out that, this can't happen. So, I guess my question is, where do we start trying to figure out, aside from whatever the new law requires or mandates, whatever, what is, how do we regulate this to begin with before it comes to a sign? Now, I understand that somebody's going to have to apply for a permit no matter what type of, alteration they might be doing to a space, but I could be opening up a shop and painting it and I would not need a permit to do that. So I'm just curious about, where does that all begin?
so
I think,
to the point that, in terms of the process, when they find out, when they go for a permit, that they're not in compliance with code, I'm afraid I come back to the fact that if I were opening a business somewhere, I would look into what the rules were in that area, and I would make sure that I had full grasp of everything before I embarked on investing in it. I would do due diligence, and that would be my responsibility. And if I don't look into it and I don't even read the local code and I invest money, then that's unfortunate, but that I should have been sharper in my initial planning. Would be my response to that, but I did.
My suggestion.
And also, this is not a new law. This has been on the books. All we did in this meeting and in the council was try to make it a little tighter in terms of the definition of the point at which at what point do you say the person has for? Because if somebody starts the application process, they get permits, they're working on it. Meanwhile, something moved at a faster pace in another municipality. It doesn't seem fair that someone who was opening their fourth location in Hudson suddenly finds because something else moved faster that this is now their fifth, because we can't ever control the future. So we were just trying to establish a point in time at which something would be
Right.
assessed. But I think you've raised some good questions and we probably need to.
I just one other question, which is getting to this whole like whose responsibility is it and how do people know? And I know this isn't the legal committees, but I think a thing that might be helpful is having something, an easy place that it's like you opening a business, what do you need to know? And there's these 10 things that as any business, because
The
you know,
Chamber of Commerce-
size business coming in is, you know, to have them be having, going through all of the zoning laws and code and all of that. It would be nice for the city to be, have a welcoming sort of like opening a business.
It
These are
would be
the,
more business friendly.
yeah, so I
This
mean,
is-
maybe. you could talk to
Commerce
the-
provides a packet for something like that, so we could maybe talk to them to provide like a little pamphlet for that.
Yeah, I mean, where do people go when they're thinking of opening a business here? Do they go to the business coalition?
Well,
That would be,
Also, you know, there's cities that require permits for doing business. You know, a permit to operate a retail establishment, a permit to operate a restaurant, things like that. Not that I'm trying to burden the city with any more work, but you know, I mean, those things do exist. And if, you know, somebody comes to town, they're opening a business, they would apply for a retail permit, whatever the case may be. And all of that information.
not earlier,
Right, that's where there, if it's not a change in use
right,
situation, which is more of a zoning question.
But
Um,
it's related, obviously. Right?
Do we have any other public comment? I see a hand raised.
Crystal Hines. Who,
Crystal?
Yes, sorry, unmute that. Sorry about that. Yeah, I think it would be important for you all to get on the same page with definitions here. Can you hear me?
No, just a moment. Just for the record, it would be helpful if people would introduce themselves. and whether or
Yes.
not that's the
Crystal
rest.
Hines, First Ward.
Thank you. Go ahead.
Yeah, I just have been listening to your conversations and I think it would be important for the council to, you know, review the definitions and get on the same page. Like the other gentleman that commented in reading the standardized array of merchandise definition, I absolutely read that as merchandise that the retailer, the retail store owner is getting, is from a single distributor, not that they're selling. I'm not sure how you look at that as them selling. That wouldn't make any sense. They sell 100% of their own product in their stores. So yeah, not only is that definition that they get their merchandise from a single distributor, but it also bears uniform markings. Now, that's my question. I'm not quite sure what exactly bearing uniform markings might mean. But I think the definitions is where you could flesh things out here so that I don't know, I think it would get everybody on the same page with what the intent of this law is even and how you enforce it. I think at this point, it is very, I'm not going to speak about any particular matters that might be pending. But certainly I think that this is as defined right now, that this is very general and it is the larger stores, probably the Gaps and the Banana Republics that are having one distributor in China or somewhere overseas produce most of their product.
Thank you. Do we have any other public comment? Okay. So I think we will leave it at that for now. Thank you all very much for your contributions. I do think that you raised good points that we need to think about.
we're definitely, I think, in the long term, trying to tighten this and make it more enforceable. That's definitely our goal. Just, you know, it's a fairly unique law, so we still have to work it out perfect, you know,
Right,
we're trying to get it perfect. And again, like I said, if something sneaks through and hasn't gotten caught, we will shut it down. Code enforcement has made that clear.
okay, thank you.
25 mile per hour speed limit.
This is just very brief. I will be working with Bristol. I've reached out to a municipality that is working on this under the new rules of the governor. And I will be reaching out to Crystal to get the process started for us to get a certification by a traffic engineer so that we can move forward on it. So I just wanted to make sure that stays on the radar. I don't really have any other updates on that. Next one, please.
New business.
The only new business I wanted to bring up, and then I'll ask if anyone else has. I did get a communication from a constituent who wanted us to look at the enforcement of vacancy law. And so I just wanted to bring that up here, that this is a question that had come up. Tom and I had corresponded on this. I do not think it's necessarily something that this committee needs to be addressing because, again, it's an enforcement issue. It's not a question of a new law or whether we need to draft changes in code and so forth. But that did come up, and I'm hoping that perhaps, I think you had indicated that Turo was working on
Michelle
it.
Tula is looking at,
Yeah.
maybe change, toughening the law, because it is, there are many ways to get around
Right.
being called vacant.
Yeah.
You know, you just get a building permit and you're no longer
Right.
vacant, and that's, maybe we can figure out ways to
Right.
make it a little tougher. I don't think it's quite the issue that it was when this first came up.
Perhaps if, you had indicated potentially inviting Michelle. I didn't think this meeting would be the best forum. Maybe if
Right.
she were to talk to us
Yeah,
at the informal,
Yeah.
that would be a good location.
because the Housing Trust Fund is also hoping to work on that, I believe,
Right.
you know.
I wanted to see if any committee members have any comment on that. Any public comment?
Rebecca Wolf.
Thanks. Lower hand.
Just introduce yourself, Rebecca.
I'm Rebecca Wolf, First Ward. And I just am aware that, the reason that the law has never been enforced is that it's not written. All I've ever heard about it is that it's got a lot of loopholes in it, or it's just not constructed properly. And so I was thinking that it could be time to, assess what are the issues with the law as written, and try to fix whatever it is that keeps it from being enforced. Because I've heard from many different angles, like including the code enforcement office that would be responsible for the enforcement, that it's not enforceable as is, or that there's no clear path to enforcement. And so anyway, it seems like a major issue, and I'm sorry that it has gone so long without being tightened, because I think that there was a study that showed how much revenue for the city this law would have created if it, or I keep calling it a law, I'm not actually sure it's a law, it's a but anyway, that's what I wanted to say. So I'm hoping that the legal committee will consider taking it up as a priority, just to get it in the shape it should be in.
So Rebecca, thank you for bringing it forward, and I think the best process here is for us to have the full council briefed on some of the challenges around this, and since Michelle Coolho is working on that, if we get a briefing on that, we can then make a determination as to, okay, this would be a good thing to take the legal committee, working with our lawyer, our council lawyer, to come up with a better version of the code. But thank you for bringing it forward. Ronnie?
Yeah, I
Yeah.
just wanted to actually, originally I was having a hard time finding the law, but I'm guessing this is chapter 91 buildings, vacant buildings. That's the one we're discussing right now.
Yes,
Yeah, it's a big one. We should study it. I was just glancing at it. I did finally find it. Do we even have, because it says here that code enforcement is supposed to submit an annual report about vacancies. Is that something that's available somewhere? Because that's probably the first thing we should look at. If we don't have a list, what's
A list is available,
it is available? Okay.
yes.
Okay. All right. Yeah, I think some homework for us to do. It's a pretty big law.
Do we
Thank
have any other comment? Any other new business? Okay. Can we have a motion to adjourn?
Okay.
Wait, there's only me and Ronnie.
Ronnie, do you?
Thanks, Ronnie. Okay, everybody, have a good evening and thank you for joining us this evening.
Thank you very much.